On this morning's docket, case number 104516, State of Kansas v. Jones.
May it please the court, Peter Meharry for Tiffany Jones. I would request 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. In this case, there's just one issue before this court, and that is whether or not the state breached the plea agreement it entered into with Ms. Jones. Procedurally, this case has bounced around a little bit on appeal. The Court of Appeals has issued 2 opinions in this case. The first one found that there was no breach of the plea agreement, and there was a dissent by Judge Atchison. This court summarily reversed that opinion and ordered it to reconsider this case in light of this court's opinions in Peterson and Urista. The Court of Appeals, with the same split, again affirmed, finding no breach of the plea agreement. Again, it was judges, I believe, Levin and Perrin finding no breach, and Atchison again dissenting. I think the facts are pretty simple. In this case, Ms. Jones was charged with 1 count of aggravated robbery. She subsequently entered into a plea agreement where she pled as charged, and the plea agreement, which is part of the record, specifically volume 1, page 42, if her criminal history was G or lower, the state will join in defendant's request for a downward dispositional departure to probation and will recommend supervision by Community Corrections Field Services. When they got to sentencing, it's our contention that the state failed to live up to their end of the bargain. The only thing the state said at sentencing was, I'm sort of bound by the plea agreement.
Well, the state did something else right before that, in that I think as part of the agreed upon kind of mitigating factors in the terms of the plea agreement didn't include the injuries or non-injury to the victim, and the state then referred to some injury that the state believed that the victim did sustain some injuries, and here's some photos, and then follow that up with I'm sort of bound by. Is that the sequence?
That is the sequence.
But by rebutting the defendant's suggestion that there weren't serious injuries, that there were no, that was not precluded by the plea agreement, was it?
That was not precluded by the plea agreement. I would, I guess, take issue with the idea that they were rebutting something at sentencing, and I think Judge Atchison points this out in his dissent. I don't think the defense, Ms. Jones, at sentencing was trying to say there were no injuries or mitigate in that regard. And I think the state, when it talked about there were injuries, I think that kind of almost was irrelevant. Because
that you're saying it wasn't in response to a suggestion that there were no injuries.
Right. So I think that's kind of water under the bridge. I think that the concerning part we have with what the state did at sentencing is by saying I'm sort of bound by it, and that's it. The state never mentioned any substantial and compelling reasons why there should be a dispositional departure in this case. And those were listed and stated in the plea hearing. The state never mentioned
in the
those.
agreement.
In the
and
agreement.
Obviously the court had the agreement right in front of it, right?
I don't know.
We don't know. Okay.
You know,
Well,
my understanding is that it was a different judge at sentencing than
Okay.
at the plea hearing.
So there's nothing in the record that tells us that the judge could look at the plea agreement and see what was in it at the time that that statement was made.
I didn't see anything in the record that would affirmatively say the judge, the judge on the record saying, I'm looking at the plea agreement. I didn't see anything like that.
Well, but the court at page 10 of the transcript at lines 13 and 14 is making some findings about the extent of the injuries, this argument about that, and says the court doesn't see that as going outside the plea agreement. So the court expresses some familiarity with the plea agreement, at least.
Well, and I think, I don't know if that means the court has it in front of it. I don't know if that means, it's in response to some of the comments defense counsel made. I just don't know. The court could have, but I guess the way I looked at the record, I don't see anything that affirmatively tells me, yes, I can stand here and tell this court, I know the district court at sentencing had that in front of him. I don't know with that certainty. you know, and there was a different judge at sentencing, which I think is important, because at sentencing, they did talk about the plea agreement. They did state the plea agreement on the record, and they also stated the basis for the substantial and compelling reasons. So, you know, the judge at sentencing clearly was not at plea hearing, so he would not have been party to that. So I just don't know to the extent the knowledge of the sentencing court. A couple things I did.
Well, let me ask you this before. What do we make of the fact that the defense counsel didn't object to what the state failed to say? I'm really seeing this more as a sin of omission than really looking too deeply at undermining the agreement. And you may disagree with that, but regardless, why doesn't the defense lawyer hold up their hand and go, whoa?
You know, I don't know. I was not obviously at the sentencing hearing. I don't know why the defense counsel didn't say something more. The defense counsel did get up and argue for the dispositional departure. That probably was his focus, to get those issues before the court. So I don't know why he didn't say anything. Maybe he did afterwards.
Why can't we I mean, I think there are two problems that come up because of this. One is whether defense counsel thought the state was in fact doing what it was supposed to be doing, number one. Then the other one is whether there's a preservation issue.
I think this is properly preserved. I think this is an issue this court can look at. This is an issue of, I think, a question of law as to whether or not the state complied with its obligations on the plea agreement. So in that regard, even if you believe or find that there needs to be some type of objection at lower level, given that it's just a question of law, and there's certainly no dispute about the facts as to what was said at the sentencing hearing, we have the record in front of us, I think the historic court can still get to it. As far as whether or not the lack of objection by defense counsel shows that he thought the state was complying with the agreement, I don't think you can infer that. I think that's speculation. And again, I think defense counsel did make arguments towards the dispositional departure, which is what they wanted. So his focus may not have been on, okay, now I need to make sure the state dots its I's and crosses its T's. So I think what you need to look at is what the state did say at the hearing. And in this case, all it said was, I'm bound by the plea agreement. It never stated what that plea agreement was, and it never went that next step, which we think they were required to do under the plea agreement, and that is to recommend probation in this case. One of the things I think is important is the fact that the probationary sentence, which was what was supposed to be recommended, requires specific findings by the district court. The presumptive sentence in this case was prison. To get to probation needed substantial and compelling reasons. And I think it's important that those need to come out and they need to be backed by the state. The state needs to recommend those. And as part of the plea agreement, they said they would, and they never did.
So it's not the qualification that I'm sort of bound by the plea agreement. It's, had he said, I'm bound by the plea agreement, it's your position, that would not have been enough.
I don't think so with this plea agreement, Your Honor.
Okay, so even though possibly, most likely, the plea agreement was before the court, defendant already outlined what the plea agreement terms were. The state saying, I'm bound by this agreement is not sufficient in your mind to, the state needs to needs to also state the terms of the plea agreement and say, this is what I agree to?
I think the state, when the state agrees to recommend a specific sentence, I think they need to come into court and say, Your Honor, the state has a plea agreement where we are recommending this sentence. And the state has to go that next step rather than just saying there's a plea agreement.
And actually, the plea agreement that I wrote down, quote, will join in, end quote, recommending dispositional departure. So the state committed to join in recommending, not to stand silent, but to join in the recommendation. And one would expect that when you join in recommending, then you join in urging the court to fulfill it.
That's right, Your Honor. I believe that when the state agrees to recommend a specific sentence, they're taking an affirmative obligation to do exactly that. And I think it was Foster that had the definition of recommend, and that was to praise or commend to another as being worthy or desirable, to make attractive or acceptable.
Was there a written motion for departure?
I believe there was, but I don't think it's part of the record. And I'm not
Okay,
sure.
so we can't look and see if counsel for the state signed it.
That's right. I didn't see it in the record, and
Okay.
I don't know why.
But the plea agreement definitely has the provision that says the agreed joint basis for dispositional departure is, and then lists all the reasons.
The plea agreement does have that, and that also was stated at the plea hearing, again, which was before a different judge. But I still think the state has to come into the sentencing hearing and take that affirmative step of actually recommending that sentence. And I think
And he did say, I don't have a recommendation outside the plea agreement.
he did
So
say
he
that.
reaffirms that, although obviously that's not a very strong statement. It is an incorporation of the plea.
He does say, I don't have a recommendation outside the plea agreement. When the court asks, you don't have anything else to say, he says, not really, Judge. Then there's a little bit of a colloquy about the pictures, and then he says, but I'm sort of bound by the plea agreement. I don't think that's enough, and I think at best that's just paying lip service to the plea agreement. As Judge Ashton noted, it probably is conveying somewhat reluctance or disdain for that plea agreement that was reached. And I think when the court says, we got a plea agreement, I don't think that's enough to say, okay, they recommended it. They have to affirmatively do that in a positive way, which I don't think they did here. And I think it's important to note, the plea agreement, Ms. Jones pled guilty as charged. She was charged with aggravated robbery, and she pled guilty to that. It wasn't a reduction in charges or severity level of the charges. She didn't plead even no contest. She pled guilty as charged. The only benefit she was getting out of this was knowing or thinking that the state was going to come into the sentencing hearing and back her on her argument that she should get a probationary sentence. Presumably, the state comes in with a good bit of weight as far as persuasive authority toward the district court when they recommend a sentence. I mean, that's probably a lot more weight than a defendant will ever have in front of the district court. And that's the only benefit she would have gotten from this plea agreement. And when the state comes into sentencing and just says, I'm sort of bound by it, we don't think she's getting that benefit. A plea is a contract, as this court well knows, implies a covenant of good faith and fair dealing. That implies the state's going to do what it said it was going to do. And just kind of giving lip service saying, I'm bound by the plea agreement, is not doing that.
Refresh my recollection. What was the first time that any sort of a statement was made complaining about what the state failed to do here?
I believe that would have been on appeal. I don't believe that there was any post-sentencing motions that I'm aware of. I didn't see anything in the sentencing hearing. So I believe it was raised for the first time on appeal.
And narrow for me, if you will, perhaps once again, why we should entertain this for the first time on appeal?
I think the first reason is I think this presents a question of law for this court, solely a question of law for this court, so I think it can reach it in that regard. There aren't any disputes as to what was done. There aren't any disputes as to what the plea agreement was. So I think it's a question of law as to whether or not the state breached that plea agreement. Further, I'm not aware of any case law out there saying that to preserve this issue, you must object at the sentencing hearing. And I don't think the failure to object changes how this court should review it. So I think for those reasons, I think this court can address it and find that the state did breach its plea agreement in this case.
Is there any kind of a fundamental right at stake here?
Certainly if the state breaches a plea agreement, that is a violation of due process. There have been plenty of cases held over the years that a breach by the state is a violation of the defendant's due process. So, I would view that as a fundamental right, and I think courts do as well. She pled guilty to get this bargain. The inducement here was the state would come in and recommend a probationary sentence. She gave up a lot of constitutional rights to get that inducement, or I should say the state got her to give up those rights, giving that inducement. By failing to actually follow through, I think certainly violates her rights and warrants this court to reverse.
Could I clarify the procedure or the posture of the case? The Court of Appeals has twice considered the merits of your argument, have they not?
Correct.
And twice we've issued or granted defendants petition for review on the merits.
Correct.
Has the state ever cross-petitioned, citing error on the part of the Court of Appeals for considering an issue that was not preserved?
No, Your Honor.
Okay, thank you.
If there are no other questions, we would ask that this court reverse this case for a resentencing hearing and have that sentencing hearing before a different judge with orders that the state comply with its obligations in the plea agreement.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. The focus here is, as we all know, did the prosecutor discharge his duty under the plea agreement? And it is our position that he did. And if you look at, we'd ask that you look at all of this in context. If you look at the sentencing transcript at page 8, before the prosecutor speaks, defense counsel is speaking, and defense counsel tells the court essentially the gist of the plea agreement, that the plea agreement's been reached. In this case, we asked you to grant her probation with Community Corrections Field Services, and then he goes into the request for the prison sentence contemplated by the plea agreement. After that, the court asked the prosecutor, do you want to say anything for the record? And the prosecutor indicates, Judge, you know, I don't have a recommendation outside the plea agreement, indicating that he is asking the judge to follow the plea agreement.
After which the prosecutor presented pictures of the injuries.
True, but on regarding the prosecutor's statement, which is the next part of our argument, if you have issues about the prosecutor's statement, I'm sort of bound by the plea agreement. He says that, again, looking at context of his statements, he says, in looking at the plea agreement, Judge, they did anticipate that she could be possibly a G or lower. Frankly, you know the word, there were injuries. There were photographs that would say Ms. Rios did not have injuries, I think is a misstatement. But I'm sort of bound by the plea agreement. Judge, when she's a G or lower, to follow the plea agreement that was negotiated. When I look at that comment,
well,
I'm
let's follow that on down. Then the prosecutor goes on to say, about the only thing I could add to statements, I could show you injuries if that would be helpful to the court. And my point is, why were the photographs of the injuries helpful to joining in the recommendation to which the state had agreed? And I think later the defense counsel went into explanation of, I didn't intend to say there were no injuries. I was saying this was a fist fight and it wasn't a deadly weapon or anything like that. But what's problematic for me is presenting evidence, physical evidence to the court that would refute the recommendation that the state is supposed to be making.
And Your Honor, I understand that, but it's our position that the comments about the injuries were not made by the state to refute the recommendation. It starts back with defense counsel. And when defense counsel speaks about these injuries, he asks the court to look at this as another factor in addition to the factors that were agreed upon as a part of the plea agreement. So when it's time for the state to speak, and he speaks about the injury and says, but I'm sort of bound by the plea agreement, as I was getting to, it's our position that that statement is not a statement of indifference towards the plea agreement. It's a statement in relation to these defendants' comment about the injuries and not being additional factor to the plea agreement. What the state is saying is, I can talk to you about injuries, but I'm sort of bound by the plea agreement here. So I don't know that I can give you more. But we would ask you to look at this.
But then the prosecutor proffered more. I can show you pictures.
He did, and then the court...
In the same paragraph of the transcript as I see it. I mean, right after he said, I'm sort of bound, but he went on and he says, well, I can show you pictures.
He does, and the court acknowledges, the district court, earlier there were questions about objections. Were there objections to what happened? Did anybody else believe in the courtroom that day that this was a breach by the state? And the district court even indicated, you're telling me that she did receive injuries, and the court doesn't see that as going outside the plea agreement. There's just a disagreement as to the extent of the injuries. Defense counsel then goes on and says, well, Your Honor, I'm certainly not advocating that she was not injured, so he speaks to it a little bit more. So the district court even acknowledged he did not believe, this is a judge with many, many years on the bench who has the plea agreement in front of him.
How do you know that?
I would say you can know that by the fact that he says, I don't see this as going outside the plea agreement. And this plea agreement is filed in the court file. I find it hard to believe that we're going to say a sentencing judge does not have the court file in front of him at sentencing when he knows there's been a plea agreement. I mean, the defense counsel has even told him there's a plea agreement. I would find it hard to believe a judge with Judge Brybieska's experience would not have that plea agreement in front of him to see what the basis was that was agreed upon.
And the problem I have with that is that the plea agreement is attached to another document, and it's not shown as being attached. So it's just sort of sitting there. And I guess I would feel better about this whole thing if the state's lawyer had just said, yeah, I join in the recommendation and the plea agreement, and do you have the plea agreement in front of you? And boy, we're a lot further down the road, especially when the state agreed to join the recommendation. You didn't just agree to be silent, you agreed to join. And that seems to communicate an affirmative duty. Does it not?
I would agree. Had the prosecutor said more, I likely would not be here.
Don't you think the word join imposes an affirmative duty on the state to do something, which would be joining?
I would continue with my thought with, as I said, if the prosecutor said more, we wouldn't be here. But I don't believe this join recommendation in this plea agreement is something out of the ordinary that's used. And in cases that I've been involved in, it is not out of the ordinary for once a defense counsel stands up, tells the court what the plea agreement is, for a prosecutor to stand up and say, we have nothing beyond the plea agreement, follow the plea agreement. They don't read the plea agreement into the court because they know the court has a plea agreement in front of them. They don't read it into the to the court again because defense counsel did that. So I understand the language join, but at the same time, the state did nothing to say they weren't joining. The state said, I don't have anything outside or beyond the recommendation of the plea agreement, indicating we have joined, we are a part of the plea agreement.
And just in that explanation, you added words to what the transcript says, and that's the struggle here. You know, if we're to view these agreements as contracts, it's pretty easy to see in a contractual relationship that something was expected of the state and that you fell short.
I wouldn't say that the state fell short. I would say that did the state come into the courtroom with pom-poms and get all excited and say, hey, judge, we have this plea agreement. This is what defendant has done. These are the reasons, the factors that we want you to follow the departure. We want you to put him on probation. This is why. No, but that's in front of the court. Defense counsel has already done that. So if this court is saying that this prosecutor or any prosecutor has to come in and stand there and read the plea agreement and say, this is what we agreed to, and I'm joining in this plea agreement, we don't have that type of case law in front of us yet. If that's what you want to do today, I would
Counsel,
agree he didn't do that.
why do you need case law to tell you to follow the simple language of the agreement? Why do you need case law that says, if the plea agreement says we agree to join the recommendation, that's what you do?
Well, I need case law because that's what I work off of. But this
Well, no, you have a plea
prosecutor-
agreement in front of you, right?
Yes, I do.
And the
this
state
prosecutor-
understands that the plea agreement is binding on the state. And the language isn't difficult to understand, is
No.
it? So,
And it is binding on the state. And I don't think this prosecutor didn't think it was binding on the state. I think that he believed it was in front of the court. Defense counsel had already stated on the record what the plea agreement was. And he said, I don't have a recommendation
let's
outside the plea agreement.
take the idea of a recommendation outside of this context, just very briefly. Indulge a hypothetical. You have a legal intern, and you agree to the legal intern. The intern said, I'm looking for jobs. Will you be a recommendation for me? And you say, yeah. And then you get a prospective employer who calls and says, tell me about this person. And you say, well, I kind of told them I would give a recommendation, but I don't have anything to say other than that. Is that a recommendation? Are you making a positive recommendation of that person at that point?
I would have to say no, but I would still say that that is different than this situation when you already have the agreed upon plea agreement signed by all the parties in front of the court. You also have defense counsel who's represented that to the court. The state didn't say, well, I'm sorry, or he didn't put on, it wasn't like Urista or Peterson, where the state agreed to stand silent. Urista, where they also put on negative information. That's not what the prosecutor did here. He simply said, I don't have a recommendation outside the plea agreement, indicating that he was joining in the plea agreement. Could he have said more? Could he have read it in? Yes, but I don't think what he did undermined the recommendation before the court, and I don't believe that this prosecutor acted in bad faith.
Let me ask the question a little differently. Let's say that the principle that comes out of this case is that when the state says it'll join a recommendation, the prosecutor needs to get up and say, we join in the recommendation, period. Is there anything wrong with that? Have we crippled this or hurt the state's ability to do plea agreements or to get them enforced or anything? Have we done any harm anywhere?
No, I wouldn't say that you've done any harm, but I would just again reiterate that I don't think that the prosecutor here didn't do that. And if you want to go to his additional comments, we would look to Woodward, and those additional comments, when he talks about I'm sort of bound by the plea agreement, Woodward indicates that if defendant attempts to minimize their culpability, state can respond to that. And that's simply what the prosecutor was doing here. The prosecutor said, I don't have a recommendation outside the plea agreement, indicating, Your Honor, follow the plea agreement. And then he responds to defense counsel's comments about the injuries.
Actually, he tried to get the victim to stand up and give a statement. The judge says, no, not yet. And then the prosecutor got into the injuries. And the prosecutor didn't simply say that I disagree with the characterization of injuries by the defense counsel. The prosecutor says, and I got visual here. I got pics. I got photos.
He did say he had pictures, and
And he says, I can show them to you if you want.
yes, but again, defense counsel said, I want you to look at this as an additional factor, and it was not one of the agreed upon factors before the court in the plea agreement. And I think that's where the prosecutor, for that moment, took issue because he believed it was not an agreed upon factor. And again, they had an agreement of which the prosecutor complied
So,
with.
Are you saying defense counsel breached the agreement first?
I'm not going that far, but I am saying that if that was the case, I mean, the prosecutor would be open. There is no agreement. What I am saying is defense counsel added a factor before the court
Open the door is what you're arguing.
to the information regarding that statement. And if you look to Woodward, the prosecutor can respond to that information unless they have contracted away the way to speak. Excuse me. They can respond to that, and I believe that's what the prosecutor is doing here.
Counsel,
Go ahead.
you've indicated your position is that basically the state did enough in this case.
Yes, Your Honor.
Is there anything less that the state could do and still be okay as far as you're concerned? Or does this represent the floor?
Honestly, I don't know. If the state contracted to stand silent, obviously that would be doing less and it would be underneath the agreement. But that's not what the state did here. But it is our position that if you look at context of what happened at the hearing, what everybody said, that the state here did enough. I agree. Could it have been better? Again, yes.
Would the following scenario be above or below what we have here? If the prosecutor, when called upon by the judge, says, "Judge, my position's in the plea agreement." Is that enough?
Well, if the judge has the plea agreement in front of them and the plea agreement is written out specifically indicating what is agreed to, I would say yes. And that would probably be an example of less than what occurred here. But I believe if you have that plea, I mean, that's why these agreements, I believe, are put down on paper so that everybody knows what was agreed to, and you can put it in front of the court. This is what the agreement was.
My question had to do with preservation. You've made no issue of a lack of preservation here, correct?
Correct. And to my knowledge, I believe it is preserved. It is a question of law, as counsel stated, and I know no case law that says in a situation like this anyone has to object. Now, I would say that that's something you can look at this hearing. You have these individuals who are all a part of this hearing, and no one has a problem with what has occurred. And so I think that's something you can look at. But no, I don't think there had to be an objection.
I'll take a little issue with that. After the prosecutor brought up about the entries, the defense counsel jumped right in, did he not, and say, "I didn't mean to imply that there were no entries." There was a long recitation in that regard. He doesn't say, "I object to the photos," but he jumped in to try to clarify so that the photos wouldn't be necessary, is how I read it. Because the photos hadn't been given to the judge when he made his recitation about what he actually meant.
You're right. The photos hadn't been given
Right.
to him yet. But I believe that was also a little bit in response to Judge Brevieska saying that the court didn't see the state's comments as going outside the plea agreement. And then I think defense counsel also minimized, we're not advocating that she was not injured, and then goes on and speaks some more about that. I don't see that as an objection in any way to what the state said in their recommendation. But again, he did not have to object. If there are no further questions, the state would ask you to find that the prosecutor here did not breach his duty and did not breach the plea agreement. Thank you.
Any more questions? Thank you, counsel. Reserve 3 minutes for rebuttal.
Unless the court has additional questions, I would waive my rebuttal.
What's the remedy here? The remedy is for your remedy, I should say.
The remedy that we've asked for is a new sentencing hearing before a different judge, Your Honor. So essentially, orders that the state comply and fulfill its obligation to the plea agreement. Essentially, we've asked for specific performance.
Sorry, asking for what?
Specific performance.
Why a new judge?
Most of the cases that are reversed for a breach of plea go down to a different judge. I think it's important to have a different judge. I think for a fair hearing, clean break. I think you just don't know if the original judge will be kind of set with what he already did. I think.
Well, perhaps the better answer is the new judge would not have seen the pictures.
That might be a better answer. I think for Ms. Jones to get a hearing, a sentencing hearing, with the state to come in and fulfill its obligations, I think it just needs to be a clean break and before a new judge so she gets a fair hearing that she should have gotten in the first place.
Has your client been incarcerated since this time?
Yes.
Or do you know?
Yeah, the sentence was, I believe,
Imposed.
59 months incarceration, and I don't believe she is out yet. Last I checked, she was not.
I'm just curious. Okay, thank you.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.